'Cause you can't, you won't, and you don't stop. Or when you can't, you won't, and you don't stop. Might be coming down for sure, shot.
Okay, so that is the requirement number 2, breach. Now imagine that we've met that we've got this, we've owed a duty of care, requirement 1 from the last module, that we've breached that duty of care under section 9, but we still have to work out whether that breach caused the harm or was the harm caused by something else. Right? Because people are only responsible for the harm that results from their acts or omission. So that's why we need to look at causation. So the key principle that we're dealing with here is that the idea of damages is to compensate the injured party for the harm they've suffered, to put them back as much as possible into the position they would have been on. So damages aren't, right, I just really want to stress this, are not meant to punish someone. They're there to compensate for the harm that the carelessness caused. Therefore, you have to show that the harm was caused by the carelessness. Our legal test for that is in Section 11 of the Civil Liability Act. So Section 11 says, a breach of duty caused a particular harm when the breach of the duty was a necessary condition for the harm, factual causation, and we actually use the but-for test, right? But for the carelessness of the defendant, the plaintiff would not have suffered any harm. So the act or omission by the particular defendant caused the harm. And the courts also look at the scope of liability. Now, I'm not going to go into a lot of detail about that, other than to say it's an important issue and it's one that's caused a lot of grief. Should you be responsible for every harm caused by your act or omission? So, for instance, if you are involved in a car accident and it injures the other person, like it's reasonable, like for the scope of liability, to cover an operation and the rehabilitation that they might have. Should it cover their lost wages? Probably, yeah. How about if they're in pain and they get addicted to heroin? Should it cover that? Should it cover drug abuse? No. Right. There is a limit. Even though it's directly related to the actual harm that you caused, the scope of liability doesn't extend that far. Now, we're not going to be lawyers, so we don't need to understand the details of this, but be aware that it's there, that it's not everything that's caused by the act or omission that results in harm is within the bounds of legal causation, right? Even though it may factually be as a result of the act or omission of the person, legally, we have this scope of liability that cuts liability off at a certain point, particularly if those kind of decisions, say drug abuse as an example, is one where the individual is actually sort of responsible as well. So as I mentioned before, the first element, factual causation, that's the one we're going to concentrate on, and it uses the but-for test. A defendant is only responsible for harm that's actually caused by their carelessness. Did the careless act actually cause the harm? But for the defendant's carelessness, would the plaintiff have suffered the harm? If in the absence of the defendant's carelessness, the plaintiff would not have suffered the harm, then the harm was caused by the defendant's. I know it sounds ridiculous. Let me give you an example. Okay. I'll leave you to look at Adil's Palace and Malbarrack, but a really interesting example involved Chelsea Hospital. Okay, and I think this makes the point very clearly. So what you had was a doctor in the hospital. Now we know that doctors owe their patients a duty of care. Okay, so they owe the patient a duty of care. The patient turns up to the hospital with a stomach ache. The doctor is actually at home in bed sick themselves with the flu, right? They haven't come into work because they're so sick. Anyway, this patient turns up. One of the people in the hospital, probably one of the nurses, rings the doctor, says, hey, we've got this guy with a stomach ache. The doctor says, well, give him 2 Panadol, tell him to come back in the morning. Well, guy comes back in the morning and dies. Turns out was poisoned. Right? Did the doctor breach their duty of care? Well, we know that they owed them. Established category. Did they breach the duty of care? Yeah, right. It was reasonably foreseeable that if they didn't do a proper assessment of someone, if they just handled it over the phone, that could cause harm. That risk was not insignificant. And what would a reasonable person do? Well, a reasonable person would have taken precautions. They would have come in knowing the probability and the seriousness of the harm. They would have come in, they would have looked at them, or they would have got another doctor to come in if they were that sick, etc., and to cover for them. They wouldn't have just sent them home. So there was definitely a breach. But guess what? The person was so badly poisoned that they were going to die anyway, whether there was any treatment or not. So the death, the harm, was not caused by the doctor not actually looking at them. Okay? So despite owing a duty, breaching that duty, that breach did not cause the harm to the individual. And so there is no legal negligence in that case. So that's a great example of factual causation, I think. So that's the third element that we need to establish. So with scope of liability, what's the court really looking at? Okay, the court's going to look at whether the consequences of the act or omission are reasonably foreseeable. We're not going to test that, just we will expect you to know that scope of liability is an important thing, and I'd like you to conceptually understand what scope of liability is, right? Your acts or omissions are things that might reasonably occur as a result, the harm that might reasonably occur as a result of your acts or omissions. That's the main area of negligence, right? What do we need to do? We need to understand what a tort is, how negligence is an aspect of tort law, and then we need to understand those 3 requirements to show negligence: that we owe a duty, that the duty's been breached, and that the breach actually causes the harm. If you can show those 3 things, then the person is negligent. But you might be thinking, hang on, there are situations where the other person, the person that was injured, was acting like a bit of an idiot, or maybe they knew what was going on. It doesn't seem right that the defendant in that case is liable. That's where defences come in. But I really want you to get clear that you use the defences after you've shown someone is negligent. Your first step is to work out whether they're negligent or not. Then we actually look out whether there are defences.